And hello, everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. I am your host, Uncivil Law, and we are here with a somewhat surprising decision from the Colorado Supreme Court that just authorized a person's testimony, or their own incriminating statements, rather, the defendant's incriminating statements to be used against him. And this was really interesting because it seems like I don't know how this decision makes sense. Let me just give you the basic facts, okay? Cops go to a guy's house. They tell him 4 times he's under arrest. They let him do things like smoke cigars and stuff, but they tell him 4 times he is under arrest. They ask him questions without giving Miranda. All right. And during this interaction, he incriminates himself. And we'd like to use that in the trial testimony. The trial court said no. And because Miranda and the state appealed the decision on interlocutory and said, we want this evidence to come in. And the Colorado Supreme Court said 4-3, yes. Despite the fact that the cops told this guy 4 times he was under arrest, they did it in a friendly tone. And they let him smoke cigars. And so it wasn't custody enough. Miranda, for those of you who forget, is when you have custodial interrogation. Everyone agrees this is interrogation. But the question is if he's in custody or not. And apparently being told 4 times you're under arrest does not qualify. So we're going to read this decision and see if it makes sense beyond the headlines. Because I haven't read this decision because I wanted to share my reactions with you. So this is brand new decision from the Colorado Supreme Court. I believe it came down today or yesterday. It was March 6th, so 2 days ago. This is an interlocutory appeal. The trial is ongoing. The trial court said the evidence can't come in. And the Colorado Supreme Court is answering the evidentiary question. People of the state of Colorado versus Brent Willoughby. All right. So we'll skip the we'll just go to the facts and procedural history. We'll skip the summary because we don't need the summary. We're going to do the full thing. All right. So 4 Longmont police officers arrive at Willoughby's apartment around 6:15 p.m. during daylight hours in uniform and carrying their service weapons. These facts, of course, are all established, by the way. So the facts here are not in dispute. I don't believe at all. The facts are agreed to because this was pretty much all recorded on body cam. So for better or worse, there are no facts in dispute. This is what happened. The officers were following up on a report that Willoughby's girlfriend made to Officer Wheeler. The girlfriend alleged instances of domestic violence, that Willoughby had assaulted her, sent threatening messages, and damaged several items of property, including artwork. Upon officers' arrival, Willoughby did not answer his door and instead began speaking to the officers from a second-story balcony while they remained on the ground below. Officer Wheeler told Willoughby about the girlfriend's allegations and asked him follow-up questions about the location of KM's property. About 1.5 minutes into the encounter, Wheeler told Willoughby, Brent, you have 2 choices. You can come downstairs or I'm going to get a warrant for your arrest. Make them get the warrant. She repeated the same ultimatum about a minute later. Willoughby denied the allegations and remained on the balcony. If this ever happens to you, just make them get the warrant. If they already have the evidence for the warrant, they're going to get the warrant. Maybe they have enough evidence for the warrant. Maybe they're bluffing. But if they have the evidence for the warrant, they're going to arrest you. They've told you, we're going to arrest you. Make them get the warrant. Don't even answer the question. Don't even answer the door in the first place. Don't answer the door. Like if the police knock on your door, just don't answer it. That also works. Why come downstairs voluntarily? Make them get the arrest warrant. Willoughby denied the girlfriend's allegations and remained on his balcony. Willoughby then spoke to a different officer about his relationship with the girlfriend, claiming she was addicted to alcohol and drugs. The officer maintained a calm tone throughout the conversation, telling Willoughby, I get that, man. I think we've all been there a little bit, and it sounds like you have a pretty tough relationship. This is not uncommon police tactics, right? Sympathize with the bad guy. Like he understands maybe you'll bro up and confess. Standard police tactic. About 15 minutes into the encounter, while Willoughby remained out of officer's reach on the second story balcony, an officer said, Brent, at this time you're under arrest for criminal mischief and domestic violence. Willoughby told the officers you can go get a warrant and come back. Now, incidentally, at this point, they need the warrant because he's inside his house. Okay? If he was outside his house, they could effect the arrest immediately. But because he's inside his house, they need the arrest warrant. So it's like saying you're under arrest. It's like, okay, go get your warrant. He's right. He's right. Go get your warrant. I don't have to come outside. And you can't come inside without a warrant. So he knows some law, or at least thinks he does. Officer immediately reiterates. So at this time, you're under arrest and we're going to apply for the warrant. Go get your warrant. Upon hearing this, Willoughby became emotional and repeatedly asked, what do I do? The officer repeated the allegations for a third time, stated that Willoughby was under arrest. We're going to take you to jail. You're under arrest. Go get your warrant. Let me know when you get it. Willoughby then claimed the property that his girlfriend alleged he destroyed actually belonged to him. Willoughby offered to show the officer his art equipment to prove ownership of the property. The officer asked Willoughby, are you willing to let me come in and look at it? Then the following exchange took place. Willoughby, if I let you in, okay, let's talk. Sure, we can talk. I'll let you in. Okay, I appreciate that. Does that mean I'm going to jail? The officer said, I'm not going to lie to you and tell you you're not going to jail. If you're voluntarily willing to go in there and look, it proves your side of the story. Then I'll probably change you're going to jail. But I'm not going to tell you one way or another. Honest answer. Willoughby says, okay, let's do this. Will you come up by yourself? I will, but I need a partner. I won't hurt you, bro. I'm not the type of fellow. I love you guys in blues. Brent, breathe. You got to listen to me. Take a breath. Take a breath. I'm willing to go into the apartment, but I need my partner to stand at the door with the doorway open. That's probably true as a matter of their own protocol. This is probably true and not a bad idea for the officer's safety. It's probably a really bad idea for the officer to go in there alone. I will take note there. She's now being invited into the house. But critically, 3 times we've already told him he's under arrest. Okay. Willoughby then gave the officer permission to enter, opening the door while crying and saying, please don't arrest me, sir. After letting him in, Willoughby showed his artwork to the officer and then discussed Willoughby's guitar and how he learned to play. Willoughby moved and paced around the apartment, picking up various objects and showing them to the officers. While inside the apartment, the officer's tone of voice remained calm. Not an invalid tactic. Throughout the encounter, the officer remained a few feet from Willoughby and did not touch him. The officer asked Willoughby if he'd like a glass of water to help him calm down and told him to take a breath. When the officer noticed that Willoughby was beginning to break down emotionally, he made efforts to de-escalate the situation by asking Willoughby questions about his hobbies. Again, a pretty common tactic, right? You ramp them up, you bring them down, right? These are all kind of common tactics. If you want a good manual on how to do police techniques, the Reed manual is the classic. It has a lot of these techniques in there, you know. You talk to them, you calmly, you try to build rapport, you can ramp them up, bring them down. Like, this is all from the textbook, as it were. Don't talk to the police. Just invoke your right to remain silent, tell them to get the warrant. If they have enough for the warrant, they're going to arrest you. Don't answer questions. Willoughby was visibly upset throughout the encounter and eventually asked the officer if he could sit down. The officer said, yeah, man, you're free to have a seat, and asked Willoughby for permission to conduct a protective sweep of the sofa, which he then performed. The officer also asked Willoughby for permission to check around and turn some lights on. He's asking. But fruit of the poisonous tree should be a thought that's going through your mind, because he's asking in a context in which he's under arrest. So these are not, if he had let him in without that piece of information, right? Even we're going to go get a warrant probably would have not done the trick, right? If you don't let us in, we'll go get a warrant, right? That's a trick. You're under arrest though. That's a misstatement about legal status. And that the police are not supposed to be able to do. The police can deceive about facts, but they can't deceive about legal status, is one of the things that typically is one of your rules. So the police can say things like, we have evidence, we have a statement, we have a video camera, we have your fingerprints, We have a polygraph that we somehow conducted of you. Don't ask questions about how we did it without your knowledge, just we did. The lies don't necessarily need to be credible. I guess it depends on what the person will believe or not. So they can lie. It's like we have this evidence, but they can't. There's two things they can't do. They can't manufacture evidence, and they can't lie about evidence. And also, they can't do other things that are unconscionable. But that's pretty hard. Like they can't make threats that that are beyond the pale. So a classic example where that would trigger would be like, if you don't cooperate with us, we're going to take away your kids. Too much. And then incidentally, your argument is not Miranda and the Fifth Amendment, right to remain silent. Your argument there is Sixth Amendment, due process. So if you want your legal for all the lawyers in the room or law students in the room, right? So if your Fourth Amendment argument fails, right, search and seizure, your Fifth Amendment argument fails, right to remain silent, what do you have left? Your Sixth Amendment argument, due process, right? So yeah. So try that. Actually, due process is Fifth Amendment too, isn't it? Sixth Amendment is right to counsel. So Fifth Amendment, not Sixth. So if your Fourth Amendment right of if your Fourth Amendment search and seizure didn't work, your Fifth Amendment right of silence didn't work. Fifth Amendment argument, due process is your next. Or is due process Sixth? Now I've confused myself. Hold on. A copy of the Constitution of the United States. I've confused myself. Hold on. Let's see. Is due process in the Fifth Amendment or Sixth Amendment? It's Fifth. Okay. All right. Fine. Carrying on. Let's see. After Willoughby sat down, the officer asked Willoughby whether officer could come into the apartment. Another officer could. He consented, and officer entered into the apartment while a third officer remained at the door. Officer Wheeler, so there's an officer standing at the door. The door is open, but he's blocking the doorway. Officer Wheeler then began speaking, saying, "Tell me about the shadow box that you broke. You sent your girlfriend a text message, and then you said your car is next. Can you tell me about that?" Willoughby responded, "Sometimes I just try to get her pissed off when she comes home." While Willoughby and the officer spoke, another officer continued to seek permission to look around the apartment, asking if he could look through the garbage bag on the balcony. Wheeler responded, No, that's just trash." The officer said okay and didn't search the bag. Still emotional, Willoughby described his concerns about Cam's health to the officers. Officer Wheeler then asked Willoughby again about text messages, which he allegedly sent to Cam, to which he responded, "I'm going to smoke my cigar. I just need to smoke a cigar." The officer then told officer to just give him a second. The officers waited while he smoked a cigar. After 1.5 minutes and approximately 7 minutes after the officer entered the apartment, the officers formally arrested Willoughby. At this point, they're in the house, though. Right. So they're in the house. They needed the arrest warrant to enter the house, but now they're in the house with his permission. And so they can arrest him now without the warrant because they're already in the house. They needed the arrest warrant to enter, but they're already inside. The entire interaction from arrival to arrest lasted less than 30 minutes. Ultimately, the people of Colorado charged Willoughby with criminal extortion, second-degree assault, unlawful sexual conduct, third-degree assault, 2 counts, harassment, and criminal mischief. Willoughby pleaded not guilty and moved to suppress the statements he made to the officers while inside the apartment, arguing it was a custodial interrogation. Following a hearing, the trial court concluded that Willoughby was in custody when he made statements to the officer. Specifically, trial court relied on the following facts. So the trial court said, yes, custody. Why? The officer told Willoughby he was under arrest 3 times. The officer spoke with Willoughby about why he was under arrest. The officer told Willoughby he wasn't going to lie and said that he wasn't going to jail. The officer told Willoughby he couldn't promise anything. Willoughby showed the officers would keep him from going to jail. The trial court found further that once they entered the apartment, the officers did not make statements to Willoughby that would have terminated custody. which is possible. And possibly at that point, maybe we need to reset, although we could still debate that too, incidentally, under relevant case law. You can't necessarily cure a problem with a subsequent corrective action by the police. The police tried this, and there was a Supreme Court case about this too once. So the police said, okay, the police tried this trick once. They like, we won't give them a Miranda for a custodial custodial interrogation. We won't give them Miranda. We'll make them confess to everything. Now we know we can't use that statement, but then what we'll do is then we'll give them a Miranda and ask them to say it again. And it's like, all right, we need to record this, so we'll give you Miranda, and we need to just go over it again. And now that we've given Miranda, we can use the second set of statements. The Supreme Court said no. Supreme Court said no to that one. It's like you've already gone to confess, and you're using the pressure of the first confession, which is improper, to induce a second confession. Fruit of the poisonous tree, right? You're using the fruit of the poisonous tree to hijack the second confession. So we've done this trick already. So taking note of that case, I note that assuming this was custodial interrogation, which apparently it wasn't, but assuming it was, it doesn't necessarily mean that police could somehow discontinue and then just continue it the right way, because that case would be parallel, right? Maybe the taint of the first thing would prevent the cure, right? It would be uncurable. So there is some case law on that point, incidentally. The trial court found further, once in the apartment, they did not terminate formal custody. I'm not sure what that would mean practically, and I'm not sure it would matter for reasons we just said. The court reasoned that although the officers did not place Willoughby in physical restraints or prevent him from moving around the apartment, they nevertheless were aware that another officer was standing at his front door, the only known expert to the apartment. It does seem to be a second floor apartment, so there's that. The trial court thus concluded a reasonable person would believe the movement was restricted and unable to leave. This is basically the touchstone. This is basically the touchstone of custody. Oh, not that sentence. I'm sorry. This one. The touchstone of whether a person is in custody is, would a reasonable person believe their movement was restricted and they are unable to leave? And we've definitely seen cases with police officers in people's homes that don't trigger custody. We've seen that. But in this particular case, they said he was under arrest at least 3 times. So, okay. The people then brought this appeal, which apparently they're able to do. Okay. We describe the appropriate standard for review. We next discuss the applicable law. We then apply the law and conclude that Willoughby was not in custody. Accordingly, we reverse and remand for further proceedings. A trial court's determination that an individual is in custody for the purposes of Miranda presents a mixed question of law and fact. We defer to the trial court's factual finding when there's competent evidence in the record to review them. We review the legal effect of the facts de novo. However, we also rely on undisputed facts in the record and independently review audio recorded interrogations, which, the videotape speaks for itself. So fair enough. The Fifth Amendment to the United States Constitution provides that no person shall be compelled to be a witness against himself. To protect this privilege, officers must provide certain warnings to individuals prior to subjecting them to custodial interrogation. Okay. Here, the people do not contest that Willoughby was interrogated, so we ask only whether he was in custody. To determine whether an individual is in custody for the purposes of Miranda, the ultimate inquiry is simply whether there's a formal arrest or restraint on freedom of movement of a degree associated with formal arrest. They told me he was under arrest, though. This is an arrest, not a formal arrest, I guess. This depends on objective circumstances of interrogation, not on subjective views harbored by either interrogation officers or the person being questioned. I mean, that much is true, but okay. Accordingly, the court must look in totality of the circumstances to determine whether an individual is in custody. We provide a list of factors for court to consider in making a determination: the time, place, purpose of the encounter, the persons present, the words spoken by the officer to defendant. I would think that'd be pretty dispositive here. The officer's tone and general demeanor. I don't know that this really is that helpful because, again, depending on the situation and depending on the cop and depending on a lot of things, cops conduct interrogations after Miranda in friendly demeanors. There's a whole good cop, bad cop thing. Of course, there's that routine, but it's not just a routine. Like, a lot of officers will try to build cordiality and build camaraderie and try to like get, feeling like we're part of the same team. So an officer interrogating you may speak to you very, very calmly and very, very respectfully, and may even offer you like water and soda and stuff. It's not exactly unheard of. So I'm not so sure how much the tone is helpful, to be quite honest. The length and mood of the interrogation. So I guess I need different mood lighting in my house. What color of lighting is best to say I'm being interrogated? That's a good question. Whether any limitation of movement or other form of restraint was placed on the defendant. The officer's responses to any question asked by defendant. Whether directions were given to the defendant during the interrogation. And defendant's verbal or nonverbal responses to directions. Although courts may consider any number of the factors, they are not exhaustive and no single factor is determinative. Okay. I mean, all right. Additionally, it is irrelevant whether the individual is actually arrested at the close of the interview. That's true. Right? You can be in custody without being arrested. I mean, that much is true. So whether or not you're arrested is not necessarily dispositive. And apparently the other way around. So yeah, apparently whether or not you're arrested is not dispositive both ways around, which seems odd. We're going to try to argue he wasn't arrested even though he was told he was arrested, which seems like a very odd determination. So if an officer says to me, you're under arrest, am I? Can I be charged with resisting arrest or not? With these principles in mind, we consider whether Willoughby was in custody for Miranda. We analyze the non-exhaustive factors in turn and conclude that he was not in custody. Okay. The officers arrived at Willoughby's apartment in early evening when it was still daylight. The interrogation took place in the apartment. When an encounter takes place in an individual home or place that's familiar to individual, that weighs against finding custody. Okay. The purpose of the encounter was to investigate the allegation of domestic violence. When the purpose of the encounter is to elicit information from the suspect of a criminal investigation, that weighs in favor of custody. Okay. Willoughby was alone with the officers during interrogation. The fact that the defendant does not have a representative or neutral party present during interrogation weighs in favor of custody. Additionally, there were 4 officers at the building, with 2 officers inside the apartment. 1 officer stood outside the door, blocking the exit, and Willoughby knew of that officer's presence. However, the door remained opened, but it's being blocked. Okay. The officer told Willoughby he was under arrest 3 times. That is significant, I would think. Courts place great weight on whether police tell a suspect they're under arrest. Though inconclusive by itself, the statement, you're under arrest, nonetheless considers evidence of intent, a part of the arresting officer to take a person into custody. I'm still back with, what do you think the probability is that an officer says you're under arrest and I fight him and the Colorado Supreme Court says it's okay because even though he said you're under arrest, you weren't. And so it can't be resisting arrest. because you weren't under arrest. So we're all good here. Do you see that decision being reached by the Colorado? I mean, it would have to logically flow, right? If you're under arrest doesn't mean you're under arrest, then resisting the non-arrest isn't resisting arrest. So it must be the case that sometimes an officer will say, you're under arrest and you can resist them, but it's not resisting arrest because you're not under arrest, even though the officer said you're under arrest. Does that seem like a decision the Colorado Supreme Court is eager to write? I have my doubts. I have my doubts here. Being advised you're under arrest is perhaps the most significant factor in determining a suspect's in custody. The one factor, however, is not dispositive. Okay. Unless the cop also happens to be an actor in a play and says you're under arrest as part of the play. I have questions here. It also must be noted that when officer told Willoughby he was under arrest, the officers were standing outside the apartment while Willoughby remained on a second-story balcony, meaning he cannot physically control or affect the arrest. A court is not likely to find custody for Miranda purposes if the police were not even in position to physically seize the suspect. So again, let's say that I'm wanted. Let's say that I'm wanted for arrest. Let's say that I knocked off a liquor store or something. And the police spot me from 300 yards away. Their eyes are really good people because, well, I'm wearing a distinctive outfit or something. I don't know. So they spot me from 300 feet away and they yell, "You're under arrest." Does that mean that I can run away? Because at the time they yelled, "You're under arrest," 300 feet away, they were not in a position to physically take me into immediate custody because they had to run and chase me down. So again, me running away is not resisting arrest because they couldn't effect arrest immediately because I was 300 feet away at the time. What if they spot me from a helicopter and they say it from a megaphone? They're 1,000 feet away and they yell, "You're under arrest. You in the blue polo, red hair. You're under arrest. Stay where you are." Does it mean I'm under arrest or not? These and other questions are questions I didn't think I had to answer the question to, but apparently this is where we're at now. It seems strange. Every court that's faced the issue has decided that telephone conversations between police negotiator and an armed suspect who's taken refuge in a building that's surrounded by law enforcement do not constitute custodial interrogation. Okay. Likely recognizing the officers could not reach him on the balcony, Willoughby said, "You can get your warrant and come back." Thus, Willoughby did not surrender the officers, but instead challenged their authority. Under the circumstances, he doesn't. Okay. The officer's statement that Willoughby was under arrest did not actually place him under arrest. See, for example, some other case holding that an individual who gave a statement while sitting in a police vehicle after showing officers where he hid the body of a murder victim was not in custody because an individual's expectation, apprehension, or knowledge of inevitable arrest are not Miranda triggers. Custody is. I mean, okay. This seems kind of questionable to me, man. Additionally, once the officers actually talked with Willoughby, they asked him open-ended questions, and Willoughby responded in narrative form. Are you trying to convince me that officers don't ask open-ended questions in interrogation? Sure they do. They do all the things. They'll ask open-ended, closed-ended. They'll be angry, sad, disappointed, hopeful, giddy, whatever they think works. They'll be your best buddy. They think you're guilty of domestic violence. They may say they understand. I know I beat my woman all the time, man. And it's just this thing I do. Whatever gets the suspect to keep talking, right? So apparently, open-ended questions is somehow a thing. And Willoughby responded in narrative form, often revealing much more information the officer's questions sought to elicit, which is one of the reasons that the officers might ask open-ended questions. Okay. The officer asking open-ended questions and individual responding in narrative form weighs against finding a custody. Okay, that seems questionable. The officers maintained a light conversational tone and calm demeanor throughout the encounter. When interrogation is in conversational tone, it's less likely to be custodial. Throughout the encounter, the officer empathized with Willoughby about the relationship, saying things like, I think we've all been there a bit, and it sounds like you've had a pretty tough relationship. Um, Colorado Supreme Court, I say this with all love, but what are you talking about? This sounds like a typical police technique. Police may be angry, they may be berating, they may try to do there's a reason good cop, bad cop is kind of a known thing. And it's not just necessarily a technique like good cop, bad cop, although that's obviously a technique where you have one officer play one and one play the other. But sometimes it's only one cop, and sometimes they're just varying through things just to see what works. So it might be the same cop. And also the cop has maybe some idea about your personality type, depending on, factors, because they've done this before. They're professionals. They've interrogated people before. So they might have some idea or some thoughts, at least, about what technique might work for you based on some factors that maybe they can't even put a finger on. But the idea that, the officers empathizing with them is not one of the tools in the bag of tricks of interrogation is absurd. I I don't remember who I read it from or who I heard it from first, but I remember an officer, or maybe it was at a law review or something. I forget the context in which I heard it, but I think it was an officer telling me, or maybe it was Fed. Again, I can't quite remember. Telling me something like, "You would not believe the confessions that I got for $5 of McDonald's." You know, or $10 at McDonald's, or whatever you would not believe the confessions I got because I bought the guy a double quarter pounder and some fries and a milkshake. Best $7 spent ever. And they'll do that. They'll do that. They'll, yeah. So some officers, and sometimes it's the officer's style, sometimes it's what they like, sometimes it's based on their assessment, sometimes they're pairing up with a partner, sometimes they go hard, sometimes they go soft, sometimes they're nice, sometimes they're mean, sometimes they are threatening, sometimes they're empathetic. They'll try anything, anything, you know. So the interrogation lasted for less than 30 minutes. A lengthy interrogation may indicate custody. Okay. And for most interrogations, the officers were outside the apartment. Speaking to him from the ground was on the second story balcony. They're inside the apartment for less than 10 minutes. 10 minutes is plenty, man. 10 minutes is plenty. The anecdote, horn line, the anecdote is a couple years old at this point. So it might be a little bit more than $7 now. Your mileage may vary. While the officers were armed, they neither drew weapons nor made any show of force towards Willoughby. Not considered bribery? No, because bribery typically requires a quid pro quo, right? They're not bribing you because they are giving you the food without any expectation in mind, don't you know? Because there's no quid pro quo. It's not a bribe. It's not even like an implied bribe because the cops are giving you the food. What would they be bribing you for? Right? So yeah, no, but nice try. Willoughby was visibly distraught throughout the encounter, often appearing to cry. In response, the officer repeatedly calmed Willoughby by talking about his guitar and other type of music he plays and asking him whether he wanted a glass of water to take a breath. At no point did the interrogation become confrontational. I don't. Does the Colorado Supreme Court not know how interrogations work? The officer did not impose any limitations on Willoughby's movement during the interrogation. The officers neither handcuffed Willoughby nor patted him down. When an officer imposes limitation on suspect's movement during interrogation, that weighs in favor of custody. See, for example, some other case noting that this court has relied on absence of handcuffs or other restraints suggesting the suspect was not in custody. Yeah. Moreover, Willoughby moved and paced around the apartment, picking up various objects and showing them the officer. When Willoughby asked the officers if he could sit down, said, "Man, yeah, man, you're free to have a seat." Indeed, the officers imposed so little limitation on Willoughby's movement. He smoked a cigar during the encounter, saying, "I'm going to smoke my cigar. I just need to smoke my cigar." While no factor is dispositive, this is significant. No one had their freedom of movement restrained to this degree associated with formal arrest would reasonably feel like they could smoke a cigar, let alone without asking for permission. Well, not to put too fine a point on it, but that could be viewed as an implied asking for permission. But okay. The officer responded to Willoughby's questions about whether the officers would still arrest him if led him inside the way suggests that Willoughby's arrest wasn't inevitable. Lol. You really serious? You're under arrest. We're taking you to jail, but it's not inevitable? Really? Okay. This is the Colorado Supreme Court, guys. I can't be wrong. So, all right. When Willoughby asked the officers whether letting him inside means he wouldn't go to jail, the officer responded, "If you're voluntarily willing to let us go in there and look, and it proves your side of the story, that'll probably change you going to jail, but I'm not going to tell you one way or another." The officer's response implied that if Willoughby could provide exculpatory evidence, the officers would likely not arrest him. Wow. That is a very, very charitable read of that situation. That is a very, very charitable read of that situation. Wow. I know the Colorado Supreme Court isn't that dumb. They're just pretending to be. The officers did not give Willoughby any directions. When officers give the suspect directions, that weighs in favor of custody. Here, quite the opposite occurred as the officers asked Willoughby for permission and direction throughout the encounter. For example, during the interrogation, the officer asked Willoughby for permission to look through a garbage bag on his balcony. When he told him no, the officer simply responded, "Okay." Moreover, the officer ensured that he had Willoughby's permission to check around and turn on some lights, and asked if Officer Wheeler could come inside and sought his consent to perform a protective sweep of the sofa. Wow. Rather than directing Willoughby, the officer took direction from him, respecting his wishes when he withheld consent. Wow. Because the officers did not give Willoughby directions, this factor is not applicable. Okay. Considering the totality of the circumstances, there are factors in favor of custody. The purpose of the encounter was to investigate the allegation of domestic violence. Willoughby was alone with the officers during the interrogation. There were 4 officers at the apartment with 2 inside of his apartment. One officer stood at the door blocking the only known exit. Officer told Willoughby he was under arrest 3 times, and Willoughby was visibly distraught. We conclude, however, the factors against custody outweigh the factors in favor of custody. Specifically, the officers arrived in the early evening when it was still daylight. The encounter took place in the living room. The officers asked open-ended questions, and Willoughby responded in narrative form. The authors use a conversational, calm tone of voice and empathize with Willoughby, and the interrogation lasted less than 30 minutes. The officers neither drew weapons nor made a show of force. The officers did not restrict the freedom of movement, and instead let him move freely around the apartment, and significantly, smoke a cigar. This is the most expensive cigar anyone has ever smoked, ever. The officer told Willoughby that if he could prove his side of the story, he'd likely not go to jail. The Supreme Court is really taking that at face value? Seriously? They're really taking the officer's statement, if you can prove it to us, you won't go to jail, or you may not go to jail. They're really taking that at face value? Okay. And the officers did not give Willoughby directions. Clearly, the factors are weighed differently depending on circumstances. It's not as simple as counting factors. But the court should not rely on one factor or absence of one factor to dictate results of the case. Doing so would render that one fact determinative. Being told you're under arrest has got to be... I mean, the failure of it may not just be dispositive, but the presence of it may very well be. Thus, considering the totality of circumstances, we must weigh factors against custody, outweigh factors in favor of custody. To support our conclusion, we turn to a relatively similar custody question in a different case, which we find instructive here. In that case, officers arrived at Davis's home at 6 a.m. Because Davis was still asleep, one of the officers entered his bedroom and shook him awake. The officers then instructed Davis to get up and asked him to move to another room. At one point, Davis asked the officers for permission to use the restroom, which the officers initially denied. The officers also initially prevented Davis from retrieving his glasses from his bedroom. That encounter lasted nearly 90 minutes. Court recognized that 4 factors indicated that Davis may have been in custody. The encounter lasted 90 minutes. One of the officers stood between Davis and the exit. The officers physically roused Davis from bed and questioned him. It isolated Davis from other members of the family. We conclude, however, that Davis was not in custody because of neutral location of the interrogation, lack of force and physical restraint, and the conversational tone of questioning. So apparently being woken up from your slumber, deny permission to go to the bathroom, deny permission to get your glasses, told to move to another room, still is not custody. At this point, I'm not sure I know what custody is anymore, guys. I thought I knew what custody was at the start of this conversation, but the Colorado Supreme Court is telling me I'm wrong. And, well, I'm not sure I know what custody is anymore, so... That case informs our conclusion that Willoughby was not in custody when he made the statements at issue here. Some of the factors that weighed in favor of custody in Davis are similar to Willoughby. The officer stood at the door and isolated the suspect. And a significant factor here that weighs in favor of Willoughby's custody was not present in Davis, namely officers telling Willoughby 3 times he was under arrest. However, some factors that weighed in favor of custody in Davis are also inapplicable here. The officers roused Davis from bed at 6 a.m. and interrogated him for 90 minutes. But here they didn't touch Willoughby and interrogated him for less than 30 minutes. I no longer know what custody is. Does this mean I'm a bad lawyer? Does this mean I'm a bad lawyer? I no longer know what custody is. This is like Crim Pro. This is second year law school, guys. I don't know what it is anymore. You think the federal court will fix this? I don't know anymore. I don't know, man. Moreover, there are 3 factors in Davis we found persuasive. As weighing against custody, they're also present here. First, Willoughby was interrogated in his living room, a neutral location. Second, the officers used neither force nor physical restraint on Willoughby. Indeed, no officers touched Willoughby until formal arrest. as distinct from the informal arrest or whatever it was before, I guess. And is free to move about and smoke a cigar. Finally, the officers used a conversational tone throughout the interrogation. The officer talked to Willoughby about his hobbies and relationship with KM, the girlfriend, and tried to empathize with Willoughby when possible. Thus, like in Davis, the factors weigh against finding in custody. Therefore, finding the totality of the circumstances, not so much. We thus reverse. I don't know what to do with this information. The police spoke to him sweetly and kindly and asked him open-ended questions. So someone asked, should you resist arrest to use Miranda? No. You always have the right to remain silent, whether you're under arrest or not. So you can always just say, I want to remain silent. I want a lawyer. To which the police might say, you're not under arrest. To which you say, I want to remain silent. I want a lawyer. To which the police might say, if you keep saying that, I'm going to arrest you for resisting arrest, or I'm going to resist you for obstruction. To which you say, I want to remain silent. I want a lawyer. So you don't have to resist. Miranda just requires them to give you the warning. You always have the right to remain silent. You don't need Miranda to have the right to remain silent. You have the right to remain silent. So you can just remain silent. Generous says, I look cute. Thank you. That's nice. I appreciate it. I'm not sure. I mean, we'll read some of the dissent for whatever value it has. The police told Willoughby at least 4 times he was under arrest. One of the officers explained that because he committed domestic violence offense, the officers had to arrest him, and further, the officers could be liable if they didn't take him to jail. When Willoughby asked point blank if he's under arrest, the answer was yes. And notably, throughout the encounter, the 3 officers blocked the only known exit from his home to ensure he did not leave. The majority nonetheless concludes that Willoughby was not in custody when the officers interrogated them, and thus the trial court erred when it suppressed the unwarned statements that Willoughby made to the police. I disagree. I think I do too. Case law directs that when an officer tells a suspect they're under arrest, courts should give that statement great weight in determining whether a reasonable person would think the freedom has been restricted to the degree associated with formal arrest. I mean, I would think so. Yeah. Thank you, Kara, for becoming a member. Do appreciate everyone who is an uncivilian and hits that beautiful, beautiful join button. Your financial contributions make this channel possible. Lesson of the day is don't move to Colorado, I think. Texas has an interesting quirk in its own state law. In order for a statement to be used against you, it has to be recorded. So that's a matter of Texas state specific law, but just FYI. Or is it any statement or is it custodial statements? I forget. Oh well, I might have to double check my law. Anyways, applying that direction, I conclude the words spoken by the officers to Willoughby under these particular circumstances would cause a reasonable person gauging their degree of freedom to conclude what the officers meant what they said, that they were under arrest. Yeah. I tend to agree. And then apparently this is what the officers were referring to when they said that they had to do the arrest, which incidentally we know from our coverage of Castle Rock. You know, it isn't necessarily what it means, what it says, but still, when a peace officer determines that probable cause to believe a crime or offense of domestic violence has been committed, the officer shall arrest the person. Some gift memberships coming in the door. Thank you, Dawn. 5 gift memberships. Thank you very much, Dawn. I appreciate that. I appreciate all the uncivilians. You guys make it possible. for this channel to exist. I really appreciate it. Thank you. Just a friendly reminder, by the way, of course, that the memberships are only 99 cents a piece. It's literally the least YouTube will let me charge you. And so you can join for a mere 99 cents. Could not be any more inexpensive. 99 cents a month is quite a bargain. You get some cool emojis. You get a cool little scales of justice by your name. And you also get access to members only content, which tends to be off-brand content. So like when I do gaming streams or stuff like that, when they're done, I make it members only. Or if I do a recording and it screws up like I did recently, it's like failed attempt to do this, I made it members only when I was done. So there is members only content from time to time. This seems like a reasonable deal. 99 cents to support the channel. Get a little members only content, the off-brand stuff. You get the emojis, you get the cool little scales by your name. What's not to like? You get the thumbnail. Thumbnails are nice. Yeah, this is where we're at, RSDefCon. This is where we're at. Am I under arrest or am I free to go? No, you're under arrest and you're free to go. You're not wrong. You're not wrong. Let's see if there's anything more in here I want to talk about. When officers conferred about best strategy for taking him into physical custody, either coaxing him into a public space or getting an arrest warrant, Willoughby called his mother. Willoughby told her there were 4 officers at the door and they were getting a warrant for his arrest. He told his mother they were going to arrest him 3 times during the conversation, which lasted about a minute. How are you free to go in your own home? Well, you could always leave your own home. I mean, or ask the officers to leave. If you're not under arrest, so you could ask the officers to leave. At least theoretically. You can leave and you can ask the officers to leave. How's that help you? After Officer Wheeler left, a different officer continued to talk with Willoughby from the sideway below the balcony. Willoughby continually interrupted the officer, trying to persuade him not to arrest him. During the exchange, the officer repeatedly told an increasingly agitated Willoughby he was under arrest for domestic violence and criminal mischief. Police had probable cause to arrest him and he was going to jail. The dialogue includes the following exchange. Officer, we have probable cause. We have text messages and photos. At this time, you're under arrest for criminal mischief and domestic violence. Why do I have to go to jail? Well, I mean, they kind of just told you the answer to that question, but still. Because we can't walk away from this. At this time, you're under arrest and we're going to apply for the warrant. I'm under arrest? You are. For what? For criminal mischief and domestic violence. We have probable cause for domestic violence and criminal mischief. We're going to take you to jail. You're under arrest. Apparently, no, he wasn't. Somehow. Get a rope ladder and descend from the balcony? I don't know. Then the officer explained to Willoughby why he had to go. If we walk away, we can be held liable if something happens. Bullshit. Castle Rock versus Gonzalez says exactly the opposite to that. The officer reminded him it'd be getting dark and he didn't want to have to put bright lights on Willoughby's apartment, thus embarrassing Willoughby in front of his neighbors. Guys, just make them get the arrest warrant. Just make them get the warrant. Call a lawyer. Call a couple lawyers at this time of night. You have to speed dial a whole bunch of lawyers trying to find someone who will pick up the phone at this time of day. I don't know if the public defender's office has a line or something, but yeah, all that stuff. What's the next thing I'm going to learn about? I'm volunteering at a local museum, and my docent training is Saturday. That sounds fun. I hope you have a lot of fun, Generous. That sounds like a nice time. A frantic Willoughby then told officer that he had exculpatory evidence in his apartment. The officer could enter the apartment to see the event. Willoughby insisted that no other officer enter the home. As he walked up to the apartment, the officer again informed Willoughby that even with this evidence, he's not going to lie to you, you're not going to jail. He's not going to lie to you, you're not going to jail. He also told Willoughby that another officer would have to remain at the open door for officer's safety. Although Willoughby did not consent to the officer entering his home, nonetheless entered the home and stood fully inside the doorway, just inside the apartment, with his foot holding the door open, which incidentally, because his foot crossed the threshold, means he's in the apartment. As the officer entered his apartment, he and Willoughby discussed Willoughby's art. Willoughby explained that he would not destroy his own paintings and easel. They conversed about playing guitar. Willoughby asked if he could sit on the couch. The officer responded that Willoughby could sit where he wanted. But before he was going to allow him to sit down, officer searched the general area to ensure there's nothing in the cushions. While the officer was in the apartment, Officer McNulty successfully contacted Officer Wheeler and asked him to return to the scene because Willoughby had allowed them inside the apartment. Upon return, Wheeler entered the apartment with two officers present and without Mirandizing him, interrogated him. This is undisputed. During questioning, Willoughby became even more distraught. He cried and smoked with the officer's permission. Willoughby told the officers that he was worried he was going to jail, but nonetheless answered questions and incriminated himself. The officers placed Willoughby in a single wing hold and tied handcuffs around his wrist, thus formally arresting him. In my view, the majority is mistaken when it employs our custody framework to conclude Willoughby was not in custody. And then they note the same factors. In my view, the majority fails to give substantial weight to the officer explained to Willoughby he's under arrest for time, and any weight to officers' numerous additional statements explained to Willoughby he had to go to jail. Instead, it gives far too much weight to less pertinent factors and weighs all the factors equally, leading to the wrong conclusion. Yeah, I tend to agree there. While an officer's uncommunicated subjective intent has no bearing on whether a suspect's in custody, the Supreme Court instructs that an officer's knowledge or beliefs may bear upon custody if they are conveyed by word or deed to the individual being questioned. And when an officer tells a suspect that they're under arrest, courts give the statement great weight in determining whether a reasonable peaceful person would think that freedom has been restricted to a degree associated with arrest. This implies that a reasonable person could hear an officer say, "You're not under arrest," and conclude, apologize the other way around. This concludes a reasonable person could hear an officer say, "You're under arrest," and conclude, "No, I'm not." And that would be a reasonable conclusion. Show me that case. Show me that case. Show me the case where an officer says to a guy, "You're under arrest," and the guy says, "No, I'm not," and he's right. Is this it? Is this the case? Can you show me a different case? No. Here, the officer told Willoughby that he's under arrest 4 times and that he had to go to jail. And while the majority acknowledges court placed great weight on whether police tell a suspect they're under arrest, it quickly pivots to emphasize this one factor, however, is not dispositive. To be sure, this is a correct generalized statement of law. It's difficult to discern here why the majority goes on to treat this factor as though it has no greater weight than any of the other factors in play. That is, the majority does not give the officer's repeated telling Willoughby he was under arrest the substantial weight case law indicates the words are due. Instead, it gives equal weight to that versus every other factor. Pretty much, yeah. I mean, it's 4 times, so doesn't it count 4 times as much? Error is then compounded by a majority's failure to arrest the officer's additional statements to Willoughby regarding arrest. For instance, the officer explained to Willoughby why the police wanted him to come downstairs and why he had to be arrested. That is, he committed a crime of domestic violence, a mandatory arrest crime. The majority doesn't even mention that statement, let alone the impact it would have on a reasonable person gauging the breadth of their freedom, alone or in tandem with the officer's other statements. The officer also explained to Willoughby that the police could not let him go because the officer faced liability if they did not arrest him. The majority, again, doesn't even mention the statement or effect this would have on a reasonable listener, particularly in conjunction with the officer telling Willoughby repeatedly he was under arrest. To my way of thinking, a reasonable person who heard the officer's statements would have no question their freedom had been restricted to the degree associated with a formal arrest. Viewed from this vantage point, circumstances like being allowed to smoke or other subtle, nonverbal, or contextual clues would do little, indeed very little, to tip the scales, which is all to say the majority also unreasonably weighs the factors against custody too heavily. Yeah. I don't know what more needs to be said about that, to be honest. I think that'll wrap up our coverage. I don't know what more needs to be said. This decision seems deeply questionable to me. 4-3, man. 4-3. And I would not depend on the feds getting involved on this one. I would not depend on this. Because what are you going to do? Appeal to the U.S. Supreme Court? And then what are you going to do? So you're going to try a direct appeal to assuming he gets convicted. What are you going to do? A direct appeal to the U.S. Supreme Court? And then assuming that fails, what are you going to do? A habeas attack? Good luck. Good luck. So I do not have a lot of confidence for this being reversed or changed. I mean, you try. Obviously, you try if he gets convicted, but I don't know, man. I mean, obviously, the Colorado Supreme Court's already said they're not going to do anything about it. So you either need the U.S. Supreme Court to take it on cert, which, good luck, or you need the federal courts to come in as a collateral attack on a habeas, which also, good luck, to be honest. So, yeah. I don't know, man. I am surprised. So the police can lie to you about being under arrest to further investigation? I guess. I wouldn't think so, because that kind of goes against the rules that I outlined at the beginning. The police can lie about facts, but they can't lie about status. And they can't shock the conscience of the court. So, but apparently they can, so I don't know. It's very confusing to Uncivil. Uncivil is confused. Let me see some of your chats. Why would it have to go to the Supreme Court only? Because you have two options here if he's convicted. You have two options. You have your vertical appeals, and then you have your sideways appeals. So if he's convicted, he would appeal to the Court of Appeals, and then the state Supreme Court, and then to the U.S. Supreme Court as a vertical appeal. Right? So those are your vertical appeals. In order to get to the 10th Circuit, you have to first go to the district court. The only way to go to the district court is by filing a habeas petition. So you say that my federal rights were violated in district court, which would then go to the 10th Circuit and then to the U.S. Supreme Court as a collateral attack. There is no direct appeal to the 10th Circuit. The only reason the 10th Circuit would come into play is if you were trying a habeas petition. Why is it okay to be interrogated before being arrested? Because to be interrogated is asking questions, and anyone has the right to ask questions, like you just did just now. That's why. Anyone can ask questions of anybody. The fact that it's a police officer is irrelevant. You can ask me a question. A police officer can ask you a question. That's why. If you voluntarily consent to answer questions, then it's voluntary. So that answers that question. Can I comment on the importance or not of law school being a grad degree rather than undergrad? Not particularly. I don't have any experience with the alternative, and you know, there's something to be said for a broad-based education that, in the US system where you get educated on a whole bunch of stuff other than just the field of interest. So the US believes in a what is the phrase? A liberal arts education. They believe in a broad-based education and then you specialize after that. So some states have countries have direct, but that is not the American experience. So I'm not sure what can be said about more than that. I've been told you can't sue an LE civilly unless they've done quantifiable damage. That's not necessarily true. You can sue not necessarily if there's damages or not. That's not the right standard. Qualified immunity, though, is a real problem, regardless of damages. Yeah. What else can I answer? Problem is more than qualified immunity? Yeah. I'm not necessarily opposed to that concept, but qualified immunity is definitely a dominant problem. Generous says I perfected the sauce for the smothered chicken burrito. To type it up and then send it to you. Excellent. Please send it to me. I liked your recipe very much. I'm looking forward to making it. As soon as I am done with my current enchilada mix that I have, I will be making your recipe. So send it to me in the next couple of days if you have time. What's even the point of qualified immunity? Well, to shield officers against decisions made in the moment and something, 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 whatever. Did anyone see the short that I posted from my Delaware Supreme Court thing? Did people like that? I thought it turned out pretty well. Yeah, I thought it worked out pretty well. Great short, thank you. How do you fight a qualified immunity situation? Do you have clearly established precedent? If so, that'd be great. If not, you have a real problem. Miranda only applies if you're officially detained. This is just a friendly conversation that'll be held against you in the court of law. Something like that, yeah. It's catch 22, qualified immunity. You don't have to tell me, right? If it's not clearly established, then the court can't find for you because it's not clearly established, which means it won't be clearly established because it's never been clearly established. So they can't find for you because it's not clearly established. So it won't be clearly established because it's never been clearly established, which means the court won't find for you, and so forth and so on. Yeah, you don't have to tell me. I know. Is there a difference between asking questions and interrogation? Well, I suppose there is a slight technical difference because technically interrogation cannot is not just questions, but also any other. I'll paraphrase because it's been a long time since I read the relevant decision, but it's other conduct that would elucidate a response. Because again, the Supreme Court's not that stupid either. So some cops were like, "We won't ask questions. We'll just like do other things that will encourage them to talk because we're not asking questions." And the Supreme Court said, no, that doesn't work either. So technically, there is a difference because interrogations can include non-questions. So there is a difference. It's been a long time since I read that decision, though. So because over the years, officers have tried all kinds of tricks, and so many of these tricks have been adjudicated before. I think the case where the court found that reasonable officer could not have known it was wrong to rob your house because it wasn't clearly established. Yeah. Marinate your fried chicken in buttermilk and pickle juice. That could work. I could definitely see that working. I could definitely see that working. Getting the ratio right would be challenging, but yeah, I could definitely see that working. If you get the pickle juice proportions right, that could be really, really nice. All right, I'm going to sign off for now. I hope you've enjoyed this content. I enjoyed this content as well, and stuff like that. And let me know what else you guys want to see and stuff like that, because I'd like to see the live stream numbers continue to rise and figure out what will help in terms of the channel grow. How we can get 1,000 people watching or 10,000 people watching. How do we get 100 times more people watching and stuff? That'd be good. Pickle juice in your vodka, that's definitely a you thing. I've never been the pickle juice. I will sometimes do a very small amount, not even pickle juice. No, pickleback. No, no, that's not for me. You keep your you keep your pickle juice away from me. That can be for you. That's fine. That is not for me. That is for you. I've been Uncivil Law. Until later, my friends, I hope all's well. Cheers, my friends, and goodbye.